Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Welcome back to the Atlanta Business and Commercial Real Estate Law Podcast with attorney Mark Battleson of Battleson Law, LLC. Mark brings over 3 decades of experience across business law, commercial real estate, and deal structuring, with a background that includes both legal work and hands-on business roles. I'm Lisa Mosbey, your host, and today we're talking about commercial lease assignments and subleasing in Georgia, and what business owners need to understand when their space needs change after signing a lease. Welcome, Mark. Thank you so much for joining me today.
Thanks for having me, Lisa.
Mark, how does assigning a commercial lease differ from subleasing space in another business, and why does that distinction matter legally?
Well, yes, I think to frame it out, you got to start with what you're dealing with from the landlord-tenant standpoint. So, there's a commercial lease in place already if you're talking about doing a sublease or an assignment. And so you've got a commercial lease. It very likely, almost assuredly, says, hey, Mr. Tenant, we're giving you this space. We are not giving it to the world and whoever you decide to give it to. We're giving it specifically to you because we've evaluated you. We've evaluated your creditworthiness as a company or a business. We've evaluated your personal financial statement as a guarantor of this lease individually. And we've evaluated what you're going to do with the space, such as have a Italian restaurant, whatever. The landlord has an interest in all of that. They want to make sure you're low risk and that whatever your use is fits what they want to do. They may not want some, vape shop with a bunch of, teenagers hanging out and, tattooed up and, just right next to a nice, old lady nail salon, it's like, that's not a good mix, right? The old lady doesn't want to walk past the kids with the skateboards out there smoking and vaping all the time. It's just not so the landlord cares about all that stuff. So getting back to your question of what the difference between an assignment and a sublease is, you've got this landlord statement of, you can't do this. You cannot assign it. You cannot sublease it without my permission. In which case, the whole process then starts with, all right, why is there an assignment or a sublease being investigated? Typically, it is for 2 reasons. The current tenant wants to sell the business. The business is going well or maybe poorly, but he wants to sell the business and then put a new tenant in there, which is going to operate the existing business. And that is a reasonably palatable thing for a landlord as long as the credit quality and the rent is paid and it's similar. The landlord will likely allow the assignment. But they won't allow you to get off the guarantee as the original tenant. Typically, you're going to be still a guarantor. So it means you as the tenant that's trying to assign the lease to a new tenant, you better make sure you're evaluating it just like you're a landlord because you have contingent liability on that guarantee. So that is different. That is a direct relationship with a new tenant that the landlord will have in the assignment to tenant number 2. A sublease is tenant number 1 subleasing to subleasee number 1. All right. And that is a contract between the tenant and the new tenant, the subtenant. And the landlord doesn't even typically have a direct contractual relationship with them, with the subtenant. And the main tenant, tenant 1, is liable to the landlord. The subtenant is liable to the tenant. And so it creates a different contract. And landlords don't like it typically, and they will typically even say, all right, look, usually it's inexperience of the landlord of a smaller property that says, okay, well, I'm not going to let you off the lease, Mr. Tenant 1, and Mrs. Sublease 1, we're going to allow you to be there, but we don't want a relationship with you. That's not typical. A landlord wants to have some action and teeth on that subtenant. So why not just allow an assignment of the original lease, modify it, and then get a direct tenant relationship and keep the original tenant 1 guarantor in place? Now, that's a long statement to the difference between the two, but it's a question of privity of contract and who is liable to who under the lease for rent payments, defaults, default enforcement, etc. And a sublease situation is a lot riskier for all the parties because there's going to probably be some gaps and enforcement problems if there is a default.
And not all leases can be assigned or a sublease can be written for those. It probably has to be in the original contract. The tenant and assigns might need to be in there somewhere. So how much control does a landlord usually have when deciding whether to approve a lease assignment or a sublease agreement?
I mean, the typical language, unless you're able to negotiate this out as tenant number one, the original tenant, is in the landlord's sole and absolute discretion. So it is, unless you get it in writing that yes, we are allowing this, and they don't even have to be reasonable. There's with respect to most subleasing, or all subleasing typically, and most assignments. If you're franchising and you maybe are growing the business and having multiple franchise locations, then you might have enough power as a tenant to say, hey, look, if I provide you with somebody that's of equal or better credit quality than I am, and that could be selling out to a corporate, like let's say you've got Starbucks is typically all corporate stores, but let's say, you're just a franchise McDonald's, whatever. I mean, that's a pretty expensive franchise, but the corporate may decide to buy your location. Well, if I'm a landlord, I'm very happy with that. And I'm going to allow that assignment because the credit quality is typically higher than an individual. So the creditworthiness may be a way to say, hey, look, I'm worth $3 million, based upon my personal financial statement. And if I bring you somebody with a $5 million or higher personal financial statement or net worth, then you will release me from the lease and the guarantee. Maybe, and that might work, but the problem is it's not an exact science on evaluating how rich somebody is. And so a landlord could say, look, this guy, he's not as creditworthy as you are, and so we're not going to allow the assignment. We're not going to approve it. And what are you going to do, sue him? You're going to end up in court trying to enforce something while your business still needs to operate. And so I wouldn't expect to ever be able to assign a lease and get off a guarantee when you sign it. So when you sign that lease, you better be very serious about taking on the long-term responsibility. And if you do have to get a new tenant in there through a sale of the business, or that you're going down in flames, and you manage to find somebody to take over that space, just realize you're probably still going to be on the hook behind that new tenant.
I have another one that came to mind. So here's my question mark. Can a business owner sublease only part of a commercial space? And the one that comes to mind is I know of a co-working space that I operate out of oftentimes, and they just recently leased one of the offices to a long-term tenant. What kind of complications can they run into splitting up the occupancy that way?
Well, it depends on who owns the building too, right? So if there's a master lease, and then there's a co-working kind of situation where people, WeWork is a good example, although WeWork, they've even made a movie about it because it was so crazy. But if the owner has the right to say who and how people occupy that space, then you need to get permission. Adding a long-term lease into a co-office or co-working space, it may create, it depends on who that lease is with. If it's with the master tenant, which is, the master tenant lease is 10,000 square feet, then it's got kind of just monthly co-working space, like a WeWork business model. And the majority of people there are maybe just licensees with rights of occupancy on a month-to-month basis under that master tenant, which is leased to 10,000 square feet. So then if there's like a long-term lease gets put into place, first, that master tenant better have an understanding of what they can and can't do with regard to creating a long-term lease. You'd have to make sure that you either had the landlord's permission if you're going to create some kind of a true tenancy versus a license to occupy. And then it's a question of who's that enforceable against. If the landlord is unaware of any of this, and then you, as the master tenant, sign a long-term lease with somebody, well, what happens if the master tenant goes into default? And then there's an eviction of all 10,000 square feet. And then you got the new sub-tenant, if you want to call it that. Essentially, it's a sublease because the master tenant doesn't own the property. So it's essentially sublease, even if you don't call it that. And so that may trigger a default from the landlord if you truly sublease. In a co-working space, you probably thought about these contingencies. But if you haven't, then you just got to make sure that, hey, look, the chain of title from the owner all the way down to whoever has an occupancy right as some kind of a tenant or licensee or a tenant sufferance. There's a tenant at will is no lease. You're just there month to month. A tenant with a lease under a lease, you've got a contract for a term of months or years, but you could be a tenant at sufferance, which is, hey, or a holdover tenant, as this third party that, or this new subtenant that signs this lease with the master tenant. If the master tenant goes out of flame, or goes bankrupt or defaults or whatever, the landlord and the other one, then the new party with a lease, likely doesn't have a contract between the two of them. In which case, it become a tenant at sufferance, and then there may need to be a separate eviction process on them. So maybe they work out a deal, but you're just exposing yourself when you add layers, you add complexity, and you add the need for better legal documentation.
You might not be wanting to commit to this big, huge lease. You're grabbing a small space thinking you're okay, but you just open up a whole can of worms. I have another can of worms for you. Can a business owner charge more than their own rent when subleasing a space? And are there lease provisions that can restrict that?
Yes and yes. So the subject to the landlord's approval for the sub tenant to even be there. All right, let's be clear. That's 99.9% of leases have a condition for that. Then a smartly drafted lease, and this happens as much more in office, but retail as well. If somebody's been there a long time, there may be a clause in there or just a separate agreement that says, hey, look, we're going to approve this. And we're going to make it a sublease or an assignment. But usually it's a sublease because the original lease, let's say the original lease is below market rent. It's $20 a foot. And today's rents, because of just inflation or this area improved or something good happened around it, now it's $40 a rent, $40 a foot. And the current tenant has 3 options to renew with identifiable fixed rents in the future. Maybe the landlord says, all right, look, I'm going to allow you to sublease this and up to the end of your current term, but we're going to kill off the future options to eliminate these effective caps on the lower rent. And we're going to allow you to sublease to these guys for the remaining 3 years of the current term, but we want 50% of the spread. So if you're going to sublease to these guys for $40 a foot, we want 10 of that difference between the 20 you're paying and the 40 you're getting. And we're going to let you do that. Again, landlords typically don't like to do that because it just complicates things. They'd say, hey, look, if you want to get out of this lease, then we'll let you out because we can go out and get $40 a foot. And maybe you just get out of it easy. But if you're going to sublease it, especially if it's for a different business, the landlord's typically going to want to say, hey, look, we'll allow you to assign the lease. You're not going to get any of the economics of the upside on this thing. And I guess I'm just thinking about this right now. Let's say they don't want the assignment of the lease means you're locking in the old provisions. And so there's probably going to be some modification, but the landlord won't want you to assign a $20 a foot lease if they think they can go and get 40 off that same tenant. So they're going to say, hey, look, You as the tenant have told us that you're going to hang on forever under this current lease. So you've got leverage over us. So we may allow you to work out something to where you can get some benefit from a sublease economically, but we want half. They're not going to just let you, if a landlord has the authority to say no, they're going to play a game of chicken with you and say, listen, you want to get out of, you don't want to occupy this space anymore. And they may even buy you out. I mean, I've negotiated buyouts of existing tenants where the landlord either has this happened up in, I can't remember what they're calling it now, but Streets of Buckhead in Atlanta. It's a super high-end outdoor type mall. It's gone through a couple bankruptcies because it originated before the Lehman Brothers crisis. And, a new landlord came in, large, private equity backed firm, and they wanted to put in a different tenant mix in the property. So they bought out a tenant of mine who had just a small gelato shop. And, we ended up getting them to pay us to go away because they wanted to terminate the lease early. And they tried to default the guy. And I was like, no, that's you're doing a constructive default. You're trying to, create a mess that isn't there. And we're going to sue you if you don't just buy us out. So it can happen both ways, but the landlord usually has the power to say yes or no. And usually the motive is either selling the business or the business is not doing well and the tenant just wants to get out. So they want to put the liability on somebody else, even if they can't get off the guarantee, but at least get somebody else in there paying for hopefully the remaining term of the lease. And long answer to, yes, you can get some negotiation on higher rents and kind of a shared benefit or whatever, but it's not typical. There's usually a lot of landlord pressure on the tenant to say, you're not going to sublease this thing and make more money than I'm making.
Well, I want to thank you for going through these hypothetical answers because there's situations that come up every day, and knowing that you have the answer and how to handle them, I think helps us all. Which leads me to ask the question: at what point should a business owner bring in legal counsel? Should they even be entertaining these conversations as possibilities without having a lawyer by their side or being the person having those conversations with the landlord?
Yeah, I mean, look, it's a self-serving statement because I sell my services to these exact things. But it is, there's a lot of complexity in these documents. And
Yes.
it's the amount of time and effort also. I mean, part of the benefit of hiring a lawyer is having somebody with some experience and understanding what the lease says quickly. I mean, I'm not going to read a 60-page lease if I get brought in to negotiate an assignment, sublease, whatever. I'm not going to read necessarily every word until I have to. And so it's going to be about understanding how to negotiate with a landlord. I happen to have worked for developers of retail shopping centers, office, and apartments. And apartments really doesn't matter because that's just, a residential lease. But, I've been involved in the leasing. I understand the pressures that the developers and owners have from a business perspective, not just as a lawyer. And so it's a matter of making sure that you're approaching the landlord in a way that follows the letter of the lease, which is going to have a process for maybe paying an assignment fee or an assignment evaluation fee at the outset, because they just don't want to be burdened with screwing around, talking to a prospective new tenant, whether that's through an assignment or a sublease, without them getting compensated for the amount of time or their staff time in evaluating this stuff. And then they got to evaluate the viability of this tenant, not just the feasibility of getting somebody in there, but then the viability of that tenant, the new one, from an economic standpoint. Is this better than where we are now from a landlord's perspective? And it might be. Right. And maybe the original tenant started out as decent, but now they struck ill. They're not a good business person. Whatever it is, they're a pain in the neck of the landlord. There could be a whole host of reasons that they were like, all right, look, man, I would love to get somebody else in here. But I'm not going to just let you off the hook to be nice. There's still going to be gotchas and hooks in you. So there's a lot that goes into it, but you better be prepared to understand the legal and what your rights and responsibilities are, and then what needs to be done to document. But on top of that, you got to know how to talk to these people and negotiate. And it's a conversation that needs to be backed up with rational basis for getting the landlord to do what you're asking them to do. Because again, 99% of the time, the landlord has in their sole and absolute discretion on approving an assignment of a lease. You know, when somebody has that kind of power, what are you going to do? You better be nice, provide a viable solution, and then pray and hope that they do what you are asking them to do.
Have somebody else speaking on your behalf, because sometimes you can get yourself into a little bit of trouble or get yourself caught in a circle that you're not going to be able to get out of if it's not your area of expertise. So
yeah, absolutely. I mean, if you're not equipped to handle it, then I don't do surgery on myself. And I don't do surgery on anybody because I don't know what I'm doing.
Well, thank you for entertaining some of these challenging questions today. You stuck with me through the whole thing, and I do appreciate that.
Thank you.
That's it for today's episode of the Atlanta Business and Commercial Real Estate Law Podcast. If you're considering assigning or subleasing commercial space and want help understanding your rights under the lease, you can visit battlesonlaw.com to connect with Mark. Thank you so much for listening. Be sure to like, subscribe to the show, and leave us a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.